Good afternoon, everyone. I'd like to welcome you to another in our recurring series of talks to Berkeley Law alumni. This one is entitled Artificial Intelligence, Algorithms, and the Courts. My name is Yuri Kapgan. I'm class of 2001. I'm on the board of the Berkeley Law Alumni Association, and I head up the Los Angeles chapter, which is hosting this talk. Just a few notes before we begin. First of all, I want to encourage everyone to attend upcoming events that we have planned, including some regional chapter hikes, which are taking place in San Francisco, in Silicon Valley on May 21st, and in Los Angeles on May 28th. Then on June 27th, Dean Erwin Chemerinsky is going to give his Supreme Court term in review. Then on July 14th, Professor Andrew Bratt will give a talk hosted by the San Francisco Alumni Chapter. The topic will be, should there be federal rules of civil procedure for multi-district litigation? And then, of course, we have our annual reunion weekend, which is happening this year, September 30th to October 2nd. The link to the event calendar will be posted in the chat here. A couple things on logistics. If you have questions, please put those in the Q&A during the presentation, and Professor Roth will answer them at the end. You can upvote questions by clicking on the thumbs up button. There's a CLE sign-in form and supporting materials that are going to be posted in the chat. Please ensure that you fill out the sign-in form in order to get the CLE credit for today's program. Those who register will receive a certificate of attendance in approximately 2 weeks. With that, let me introduce Professor Andrea Roth. Professor Roth joined the Berkeley Law faculty in 2011 after 3 years as a fellow at Stanford and 9 years as a trial and appellate public defender in Washington, D.C. Her recent articles and book chapters include the use of algorithms in criminal adjudication, admissibility of DNA evidence in court, prosecutors as surveillance entrepreneurs, and machine testimony. She's also the co-author on a leading evidence case book and a scientific evidence treatise. In 2021, she was appointed chair of the Legal Resource Task Group of the National Institute of Standards and Technology's Organization of Scientific Area Committees, and is one of several faculty co-directors of the Berkeley Center for Law and Technology. She's also an elected member of the American Law Institute. In 2019, Professor Roth was one of 4 recipients of the campus-wide Distinguished Teaching Award. In 2017, she received the campus-wide faculty award given to one pre-tenure woman faculty member. In 2016, she received the law school's Rudder Award for teaching excellence. She's also received teaching awards from the Women of Berkeley Law and the Berkeley Criminal Law Journal. So with that, Professor Roth, I'll turn it over to you.
Thank you so much. Hi, everyone. Thank you so much to Yuri for that overkind introduction, to the Alumni Association for hosting the talk, and to the Berkeley Law alumni out there. We miss you. Please stay in touch. So without further ado, let me share this and I will get started. Let me know if anything is amiss here. So what I'd like to do with our brief time today is cover just a few topics. First of all, I'm going to define terms here so it's clear what I mean by AI and algorithms. They could mean a few different things. I'm going to talk a bit about how they're being used. I'm going to focus on criminal cases because that is my area of expertise. But if anybody has questions, if they want to ask in the Q&A about any of this in civil litigation, I have thought a bit about that. What legal and policy issues are raised by these uses of AI and algorithms in criminal cases, and what should we do about it? Okay, I should also say I would love to field Q&A throughout the presentation. I definitely will leave time at the end for Q&A, so no pressure at all, but I don't want to be big on ceremony. I'd love to get to the things that matter to you all most. So feel free to put Q&A in there as we go on. Okay, so what do I mean by artificial intelligence and algorithms? Well, we have, the top, computer, one of, if not the top computer science department in the United States. Stuart Russell, wrote the book on artificial intelligence. So there's a lot of different definitions out there that are a little bit broader than this. But when I'm talking about AI in the courts, I mean the use of computers to engage in problem solving or rendering facts, or what we might call opinions, claims that traditionally have been rendered by human actors in the legal system. And so, expert opinions, factual claims about whether somebody's a contributor to a DNA sample, or what psychiatric disorder they might be diagnosed with, things like that. Okay, and algorithms are the computer programs, or the steps that a computer follows in performing those tasks. So an algorithm might mean software. It doesn't have to be. An algorithm could just be a recipe, a list of 10 steps. It's a generic term here. I'm talking mostly about software. Okay, so how are they being used in criminal cases? Of course, they've been used for decades, but we're really seeing a paradigm shift in evidence in criminal cases. So let me just give you some examples at each stage of a criminal case. In terms of criminal investigations, you are seeing, for example, surveillance cameras on streets of cities that can pick up what they think to be, let's say, a drug transaction. It's a machine learning algorithm that uses a data set of, say, known drug transactions and non-transactions, and then it looks at an event, and if it deems it to be a drug transaction, it sends an alert to the police. And so it's not simply a surveillance camera, which is itself a technological innovation in policing. It's actually drawing conclusions about the likely criminality of a particular event that would otherwise be an innocuous handshake between two people on the street. Okay. Neural networks are now being used to determine whether, let's say, a crime is gang related for purposes of criminal enhancements under statutes. My former colleague at the DC Public Defender Service, Andrew Ferguson, has written the book on big data policing, using algorithms to determine, for example, which hotspots in a city police should focus their resources on. Axon, who created the taser, has an algorithm they were working on to determine whether a videotaped confession in a station house is a false confession or not, based on software that looks at microexpressions, text analysis, all of that. And we have facial recognition software that's being used now by 18,000 police departments around the country. We have a very decentralized criminal justice system compared to other countries. So these decisions are often made at the department or city level. Okay, next big category is risk prediction, both pre-trial at the sentencing stage and at post-conviction stage in determining whether somebody, for example, should get parole. Compass is an algorithm that's made the news a bit. It's used in the post-conviction space to determine parole eligibility. Something called the PSA, or the public safety assessment, is typically used in the pretrial space. These risk assessments are used more often in part because of the movement to end cash bail. So if you get rid of cash bail, what do you replace it with? Some reformers say don't replace it with anything. Most reformers, including like Chesa Boudin, have replaced it with an algorithmic risk assessment tool. Okay, and ProPublica has done an audit of Compass in which they claim that they found that there was a higher false positive rate for Black defendants than for white defendants who are subject to these scores. I'm just looking at the chat. Okay, that's not for me. great. And then what I focus the majority of my research on is proof of guilt or innocence, or violations of probation or parole or pretrial release. Essentially saying this is evidence, not just that should trigger a probable cause determination, but should be used, let's say, at trial. So here's just some examples. There was a Ninth Circuit case recently involving illegal reentry into the United States, where the government had to prove that somebody had been arrested in the mountains between Mexico and the US, had been arrested on the US side of the border. And so the way that they showed this was the border agents put in GPS coordinates into Google Earth, and then the pin dropped on Google Earth, according to the Google Earth's map, was on the US side of the border. The defendant in that case said, no, we were definitely in Mexico. I could see the sign. There must be something wrong with the algorithm. And the Ninth Circuit said, there could be problems with this, but the objection that was made in the case was a hearsay objection. And I don't know if you all remember what hearsay is, but the idea is that it's an assertion by a human being made out of court, and it's offered for its truth. And it is an assertion offered for its truth, but it was made, according to the Ninth Circuit, by an algorithm, not a human. So it's not subject to the hearsay rule or the confrontation clause or anything like that. Intoxilizer, now, all of these breath alcohol machines are governed by software. There's a New Jersey case in which an expert did a report on the software for one frequently used program, saying that it could lead to false positives. And the court acknowledged that, but said that it wasn't an issue in that particular case. So it's been an ongoing issue. Defense attorneys trying to get the source code for it and things like that. Just to give you an idea of one case in DC where the government claimed, it was a homicide case, the government said that the defendant had tweeted out a confession to the murder. And it did come from the defendant's Twitter account. So the defense in that case hired a computer science expert from Israel, Oren Zur, who trained 3 machine learning classifier algorithms on data sets that comprised tweets from the defendant and then from various other people who had access to the defendant's Twitter account. And this scientist found that all 3 of these algorithms said he wasn't the author of the tweet. You can imagine a case tomorrow where the government hires a scientist and where the scientist says he is the author of this note. So you're seeing artificial intelligence used to determine authorship of text, and it can be highly relevant in criminal or civil case. All right, and you see statements of probability. This one's called a likelihood ratio or a match score, coming from software that interprets complex DNA mixtures and tries to figure out whether a particular defendant is a contributor to a mixture. You see driving estimates from Google Maps being used to determine whether somebody's alibi is viable. Fitbit data used to say, in one case, that an alleged victim of a sexual assault was actually asleep at the time that they claimed to have been the victim of an assault, where they claimed that they were awake. You see now these haven't been used in criminal cases, but I want to just mention them as something that could be on the horizon. IBM's Watson now is actually diagnosing certain illnesses, and I think it's really only a matter of time before we see AI diagnoses of psychiatric conditions or other conditions that might be relevant, where you otherwise would have a human expert making the determination in both civil and criminal cases. And researchers at the University of Michigan, and I'm sure other shops as well, are starting to do text analysis, lie detection through text analysis. All right, so these are just examples of what is actually happening, or I think could reasonably start to be on the horizon. So what legal and policy issues do these uses of AI raise? So just today, hot off the presses, the National Academy of Sciences came out with a report on fostering responsible computing research, sort of like AI and policymaking in the United States. I had done a presentation to them on AI and criminal justice that, and there were many others who focused on other domains like healthcare and such. The report, the pre-publication report, is now available on the internet. If you just Google that title there. But one of the takeaways is to determine, ethical use, you've got to go back to the values that govern whatever domain you're talking about. So starting point for criminal justice would be, well, what systemic values are we trying to promote through our criminal legal system? And I'm going to put some out there that are basically discussed in the discourse and agreed upon. One, these may seem obvious, but once you actually focus on them, you can see some of the problems that have been developing in the use of AI in the system. So we've got accuracy and procedures designed to test accuracy, like, say, cross-examination, fairness, legitimacy, something that Tom Tyler from Yale would call procedural justice, that people need to feel like the process is fair, if they have a voice, if they're treated with respect, if they deem it to be a fair and neutral system along various axes, if they understand why what is happening to them is happening to them, and if they view system actors as helpful. Dignity. For example, even if torture were an accurate way of determining information, there may be reasons based on personhood that we just don't use those modes of proof, however accurate. And then, of course, we're not writing on a blank slate here. We've got legal doctrine. We have the Sixth Amendment right of confrontation and compulsory process. And so we need to figure out, does the use of AI butt up against those rights in some ways, or enhance them? Okay, so let me give a few examples of how these values are potentially jeopardized or enhanced by the use of AI and algorithms in criminal courts. Let me just give an example of DNA software, probabilistic genotyping software. There was a case in upstate New York involving the tragic death of a 12-year-old boy, and there were no suspects. The mother was not a suspect. There were two ex-boyfriends of the mother that became suspects. One of them had an alibi. One of them had a domestic violence past, but had an alibi that the authorities believed. And so suspicion rested on a man named Oral Hillary, who's the man in the tie here. He was the coach of the local college soccer team in Potsdam, New York. So the problem for the government was that there was no evidence against Mr. Hillary, no motive, no anything. So the case went cold. They did find eventually some tiny bit of DNA under the boy's fingernails, and there was enough there to do some testing, but it was a very complex mixture, low quantity, so human analysts couldn't do it justice. So they sent it to one of two major software companies that make software to interpret complex DNA mixtures. This one is called TrueAllele, run by Mark Perlin in Pittsburgh out of Carnegie Mellon. And the TrueAllele software, which has been used in several criminal cases and also several exonerations to show that somebody, was not the contributor to a mixture. Here, TrueAllele determined that Mr. Hillary was not a contributor to the mixture. And so the case went cold again. A new district attorney was elected on the platform of finding the boy's killer. And that district attorney sent the same DNA sample to the competing company. These two companies are now in lawsuits against each other involving intellectual property infringement and various other things. StarMix determined that Mr. Hillary was a contributor to the mixture. And note that this was based on the exact same DNA sample. They didn't have a different sample they were working from. It was simply a different algorithm, a different set of instructions. And these are very complex programs. TrueAllele is like 170,000 lines of code. So you had the StarMix result that was inculpatory, And so the government went ahead with the star mix result. A judge determined under the Fry test, which is still the test in New York, judge determined that the method was not valid, was not generally accepted as applied because the local lab had not done enough internal validation on the software to prove that it worked with their equipment. So they excluded the star mix result and Mr. Hillary was acquitted. Now, I can't purport to know who killed this 12-year-old boy, but I think for purposes of this discussion, what is critical is that two algorithms came to very, very different results, and that if we only had the benefit of one of them, we would, and we assumed that it was accurate, we would just go with that. And so obviously there are choices being made in the code that can be dispositive of guilt or innocence in front of a jury, let's say. Okay, that's John Buckleton, who runs StarMix. Okay, another example on accuracy, facial recognition software. You've probably heard in the news various concerns about how the software has a much higher ability to misidentify people of color because the databases are not sufficiently robust, among other reasons. There's a man in Michigan, Robert Williams, who recently was actually falsely accused of a store robbery based on facial recognition software. And I think it's important to note a few things about this case. One is that the software was compared to his driver's license picture. In other words, part of the reason that misidentifications happen from these new technologies is who's in the database. And so if you have everybody in the database because of their driver's license picture, then the people who are most likely to be misidentified, it's going to happen to them more often than it's going to happen to, white people with driver's licenses, even if they're in the database. The other concern is that if they're getting it from, existing, let's say, mugshots or whatnot, you're sort of zeroing in on a usual suspects population and possibly misidentifying them from there. What happened in this case was arguably something that a co-author of mine, Valina Beatty from ASU, calls a cascading effect, which is they took this alleged match. They thought Mr. Williams was a suspect before they even talked to Mr. Williams. They went to a store employee who hadn't even witnessed the robbery themselves, and they picked out Mr. Williams from a photo array where the other people in the photo array, according to Mr. Williams, I haven't seen it, look nothing like him. And so, the facial recognition software result was used and arguably tainted the later identification procedure. So eventually, the case was dismissed when it was obvious it wasn't him. He looks, even the police, when they went to his house and actually saw him in person, said, "Oh my gosh, I guess the computer made a mistake." I guess so. So another example is the Brandon Mayfield case. This is an old case. This is from 2004 Madrid train bombing. I don't know if you remember this, but Mr. Mayfield was, he, like so many of us, have our fingerprints in some DNA data, for some government database somewhere. You have to when you become an attorney, and Mr. Mayfield is an attorney. At least in California, I had to give my fingerprints. And they took latent prints off of an item from the crime scene, and they put it through the US database. And the system, like other systems of its kind, spit out the top 10 matches. They said, "Lo, these folks look very much like these latent prints." And Brandon Mayfield was the top match. And so they assumed he was guilty. And in fact, when they found out more about him, they assumed he was even more likely to be guilty. Of course, these are innocuous details about him. This was right after 9/11. They found out that he was a Muslim, and they found out that he hadn't left the country in, I think, 5 years. And so these details, again, these perfectly innocuous details were infected the investigation through what I would call confirmatory bias. So after it became clear, the Spanish authorities said, actually, we found an obvious match. It's definitely this other person. The FBI had to apologize to Mayfield, recognize the mistake, say this was a false match. And then there was a huge inspector general report afterwards to think, what happened? Why did this happen? And this is where I want to zero in on the artificial intelligence part of this. It was because none of the top 10 matches included the person who was the actual source of the latent print. But there's this phenomenon called automation complacency, where we assume that when the computer spits out something, the right answer has to be there. And so they call it, the Inspector General's report called it a particular hazard of this computer program. I do have a couple of Q&A. Let me just read them, and then I'll see if I get to it later. You may already plan on addressing this, but could you focus on evidentiary issues regarding admissibility of AI at trial? You mentioned Frye and Daubert, the governing standards, and what rights does the defendant have to access? All right, excellent. I will be talking about that in a bit later, but just let me jump to the quick answer, which is because the hearsay rule and the confrontation clause, most courts have said, pretty much all courts have said, don't apply to machines as witnesses. Really, Frye and Daubert are the only things right now that defendants can use to justify finding out more about these computer programs and subjecting them to any type of reliability test. But remember that Frye and Daubert only apply to human experts. So only when a human expert uses a computer program as the method for rendering an opinion are they subject to Frye and Daubert. So you have People versus Lopez, which is a case in California. I'll show you a key quote from Justice Goodwin Liu, former Berkeley law professor that many of you might have had, where there was no human expert. And so you just had the results of a gas chromatograph come into play. I should also say that Frye and Daubert only apply at trial. So like in State versus Loomis, this Wisconsin case involving Compass, if you're dealing with a post-conviction algorithm or pretrial algorithm, it's not subject to Frye and Daubert. So there are gaps, and I'll talk a bit about my own research trying to suggest enhanced discovery rules and changes to the confrontation clause doctrine. Another question from John McMath, class of 2009, former public defender turned lawyer for VR startups. Wonderful. Where has the law landed on who owns a work that's produced or generated by an AI or algorithm? I will defer to others on this. I know that there's a great, it might be by Tim Wu. There's a great article on free speech rights of works produced by algorithms and such. My own view, for purposes of this discussion, which I'll get to in a few minutes, is that this claim that's coming out of these algorithms, the claim that you are a contributor to this mixture, the claim is being made by the computer, not by the programmer. So there are various issues with, who's morally responsible for the results of an algorithm. If you make a self-driving car program that ends up killing somebody, maybe it makes sense to sue you. Maybe it makes sense for you to have some ownership interest over something when you're the programmer. But for these purposes, when the question is, who has actually made this assertion? And how do we get into the inner workings of the person or thing who has made this assertion to test the likely accuracy of this assertion? Then having the programmer on the witness stand for a couple of hours, when the program itself involves machine learning and tens of thousands of lines of code, isn't really the answer, I don't think. Okay. I'm not sure how to get rid of the questions, but I see those are the two so far, and I've answered them, so I'm going to keep going. But let me give a couple of fairness examples because I do want to get to solutions, which involves answers, more elaborate answers to the questions that have been asked. So one problem here is, again, Compass has a higher false positive rate for Black defendants and white defendants. That's demonstrably true. The North Point, the company that created Compass, their retort is not, no, you're wrong, the false positive rates are the same. Their retort is, yeah, that's true, but that's always going to be true when the base rate is higher for one group than another. And Black defendants have a higher rate of recidivism than white defendants. And so what you should be looking at in terms of racial fairness is whether or not race has any predictive power in our model. And they say, when you have a Black defendant who has a score of 10 and a white defendant who has a score of 10, they both have the same risk of reoffending. And they say that's what should be the measure of racial fairness and not false positive rates. Now, how do you answer that question? You have to define what you even mean by algorithmic fairness to determine which measure you should look at. So this is a major issue for use of algorithms in the court system is we have to define what we think the best measure is of fairness to decide whether something is discriminatory on the basis of something like race. Let me just talk just for a second about examples of uses of technology that have raised legitimacy and dignity concerns for some. This is a picture of James Frye from Frye versus US, who he claimed he was being falsely accused of homicide in 1920s DC. This is William Moulton Marston, who created Wonder Woman, the truth lasso. He also created one early version of what's commonly called the polygraph. And Marston administered a polygraph test on Mr. Frye and said, he's telling the truth. He didn't do this. He's being falsely accused. And the court said, no, sorry, this is not, this is still in the twilight zone. Polygraphs haven't risen to the level of general acceptance yet. Polygraphs in general have since then become what's typically called an evidentiary pariah in most jurisdictions. Of course, the government uses them, frequently in post-conviction proceedings, but in terms of trial, no. We don't want defendants proving their innocence through polygraph results. Part of that is a fear that they can take as many tests as they want until they pass one and then say, look, I passed. But I think there are ways around that. But I think it's an example of something that at least one justice of the Oregon Supreme Court has famously said is dehumanizing. They said, I don't want to be treated like, just a bunch of electromagnetic pulses. I'm a human being, for goodness sake. Okay, there are, Franz Kafka in the Penal Colony has this short story on this awful machine that inscribes things on somebody's back, basically saying guilty or innocent, and raising questions about dehumanizing beyond the accuracy of the machine. I know that that's fiction. This is a photo. This is a picture of something called the penile plethysmograph, which one of my former students, Chandra Peterson, who's now at the Federal Public Defender in San Diego, did a paper on in one of my classes. And they hook you up to this machine to determine your arousal level based on various images to see if you're lying when you say you have been cured of various forms of what they deem sexual deviancy. So, I think there could be concerns about that that are based on accuracy, and there could be concerns about that based on just basic human dignity. And also explainability. If we decide that we have a very accurate system that just, total black box, nobody knows how it decides what it decides, but it is totally accurate. Somebody says, trust me, this is 99.999% accurate. And it's just an oracle that says this person was there that night, this person committed the homicide, would we have some sort of legitimacy problem with that because of its lack of explainability, because we can't figure out why it's doing what it's doing? So that is becoming more and more of an issue as we go from, just basic computer programs that determine blood alcohol level to something like Watson that determines whether you are malingering when you say that you have a delusional disorder, let's say. Okay, so what should we do about all of this? If I've convinced you that there are some issues with the use of AI, what should we do? I'd like to work backwards for a second from some of the problems that I just pointed out and to think about maybe how those problems could be avoided in the future. So you could, for example, require as a condition of admission validation studies that test what I'm going to call the full factor space. This is a phrase that was used by NIST in a recent study of DNA mixtures, where it looked at all the computer programs that purport to interpret DNA mixtures, and it said, these computer programs hold great promise. The problem is, and they do have some validation studies showing that they have, in general, low false positive rates. They don't call somebody a contributor to a mixture when they're not. The problem is that the validation studies don't deal with the most difficult cases. And so they say, what we really want is validation studies that give us some level of certainty about how this tool is going to work in, say, a case with 5 contributors to the mixture instead of just 2 or 3, which makes it more complex. In a case with a low amount of DNA as compared to a high amount. In a case where the contributors to the mixture might be relatives or might share a lot of genetic markers between them, which makes it even more complex. Things like that. And so they say, you don't have to have a validation study that goes on for 10 years. You just have to carefully design it so that we can draw reasonable inferences about the accuracy of a tool, not just under ideal conditions. Allow licenses to independent academic researchers to conduct audits of this technology. We have computer scientists at Berkeley right now who have asked for a license to do research on star mix. And the basic answer has been no. Unless you're going to do forensic casework with this, we don't trust that you're not going to say something misleading about our technology. So these are proprietary algorithms. Nobody gets to see the source code except under gag order for a very small amount of time. And, it's nearly impossible, as far as I can see, for researchers to get to be able to audit them. Submit to interrogatories from the opposing party about the systems, models, and assumptions. That could take the place of cross-examination, because you can't cross-examine star mix on the stand. Subject it to independent software testing like IEEE, and industry standard software testing like the elevator in your building is subjected to, but that this technology is not. Yes, this stuff is subject to Freien-Daubert, but this is the sort of thing I think we need, that with a human witness, with a human expert, even when their testimony is deemed admissible under Daubert, you get tons of discovery, you get to cross-examine them, you get to talk to them pre-trial, you got lots of stuff to work with to impeach their credibility, even if their opinion is admitted. So this is what I think we need to do for machines. Instead of just thinking about their admissibility and whether they have a basic level of reliability, we've got to be able to find ways for people to scrutinize them the way that we can scrutinize human testimony. Maybe we even need a rule, like a 2-machine rule, saying we just have much more confidence in these results if we've got 2 machines that are competing against each other that both say you're a contributor. Access to prior runs of the machine. Was this run more than once through this machine, and did the likelihood ratios differ each time? That would be for those of you who practice in the federal system, that would be sort of like the Jenks material of the machine. And I think that both parties should get it. It's a harder case whether there should be source code. There are a lot of, my colleague Rebecca Wexler has written about trade secrets and how there shouldn't be a trade secrets privilege against getting access to source code. There's a debate about how much you need access to the source code itself. Several experts say yes, but that's a constant area of litigation. Just a point about validation studies. This is basically, you don't have to know anything about a method to subject it to a validation study to determine how often it gets it right. Like you've got a gas chromatograph that tries to decide whether something is baking soda or cocaine. You can actually test that. You don't have to know how the machine works. You can test it since you know the ground truth, you know what's baking soda and what's cocaine. You can stick it in the machine and see how often it misidentifies baking soda as cocaine, how often it misidentifies cocaine as baking soda. You can find out its error rate in that way. But what about a score, like a credit score, or a likelihood ratio that's spit out by one of these DNA programs? That's harder to determine what the ground truth is. Let me give you a quote from a couple of statisticians. Laboratory procedures to measure a physical quantity, such as concentration, can be validated by showing, the measured concentration lies within acceptable range that But such validation is infeasible for software aimed at computing a likelihood ratio because it has no underlying true value. We don't know what your real credit score is, or it should be. So for those types of algorithms, we really need to know more about why it's doing what it's doing. We can't just take it as a black box and subject it to a validation test and call it a day. All right. Working backwards from the facial recognition problem in Mr. Williams' case, maybe we shouldn't allow such a result to justify an arrest until data sets are more robust and fair and the false positive rate is lower. Maybe we should limit eyewitness identifications to people who actually witnessed the event and get as much independent, untainted information as possible from that person, like a full physical description before you give them a photo array that was created through use of facial recognition technology. Backwards from the Mayfield problem, just adding a couple more things. Require investigators to explicitly consider the possibility that the matching person isn't present to eliminate automation complacency. Require disclosure of the other top matches generated by the algorithm. That could be the jinx of the machine, again, if you will. Eliminate use of database hits as justification for arrest until the method has been sufficiently validated, like DNA has. All right, and let me jump in with another question from Walter McMath. One more question based upon your points about insisting on more material to audit the machines, access to previous studies, competing machines, et cetera. How do we get judges to grant discovery of those materials or legislatures to include a statute, especially when many criminal judges will assert that the lack of additional checks goes to the weight and not the admissibility? I agree. I think that you'll get the weight not admissibility thing a lot in the Fry and Daubert challenge. I think that some of this may require changes to Rule 16 or its state analogs. Some of it you can say you should have a right to inform your Daubert challenge. Some of it I think you can make a confrontation clause argument for, which I'll make in a second. Some of it you can ask for voluntarily and then cross-examine on their refusal to give it to you, or maybe get a missing evidence instruction. Representative Mark Takano from Southern California has a bill, the Justice and Forensic Algorithms Act, that Rebecca Wexler and I have been a bit involved in, and also was inspired by the work of Christian Chessman, who's also an alum. So I think that type of statutory change would give more discovery rights in that way. But that's exactly what I'm talking about, a move towards impeachment and discovery rather than simply focusing on admissibility. And then another question, I wonder if you're going too far in absolving the programmer. Perhaps they shouldn't be forced to testify as a proxy for the machine, but don't they inevitably play a critical role in building the algorithm? Absolutely. They should be part of the Fry and Daubert hearing. perhaps they should also have to testify at trial. My only argument is that it's not sufficient on its own necessarily, that we can't, as a general matter, say, so long as you can cross-examine the programmer, you have absolutely no argument that you lack sufficient information to scrutinize this machine result. That is what I'm pushing back against. And, the New York an intermediate court, New York Appellate Division, in a case called People versus Wakefield, essentially said that, hey, they get to cross-examine the programmer. This is a really good question for academics. We can't wait to have coffee and think about it. But in this case, good enough that you were able to cross-examine Mark Perlin, the proprietor of Trulio. And that's what I think is problematic. And then use the power of technology to measure the rarity of characteristics and quantify error rate. Fingerprints is just something that we don't have a quantified error rate for in the way that we do for, say, DNA, where we can say, we know exactly the rarity of genetic markers in the population, or at least an estimate of them. Okay, all right. Working backwards from COMPAS, we got to agree on what we mean by algorithmic fairness, eliminate perverse incentives to spend money on these algorithms rather than more fruitful ways to identify and reduce recidivism risk. So one of my current research assistants, a brilliant 2L here at Berkeley, Kendra Dawson, is writing a paper now in Professor Wexler's class, making this point that, but instead of just talking about whether this algorithm is accurate or not, we should be talking about why we're funneling so much money into the development of risk scores instead of and in place of funding programs in prisons and jails and communities that reduce recidivism. It is a zero-sum game and it's problematic, she says. And then Rebecca Wexler has argued for eliminating the trade secret privilege for something like COMPAS. And I'll leave it at that. In terms of legitimacy dignity, my new colleague, Osagie Obasagi, who used to be in the School of Public Health and is now in the law school as well, has suggested that these new technologies be forced to include a racial impact statement. And I think that sort of impact statement could be like a human impact statement, looking at these sort of, bioethics concerns. He's a bioethicist, and I think that is something that people like Professor Obasagi could be working on. Explainable AI, this is a whole field. I'm not an expert on it yet, but this is something that I think is important for legitimacy, and we need to just flag it as an issue for the criminal legal system. And then human in the loop. We've red light cameras. Everybody hates red light cameras because they feel like I had a good reason for running that yellow, or, if this had been a human police officer, I would never gotten the ticket. I think that's a sign that maybe people want a human in the loop. And maybe that's a somewhat trivial example, even though tickets can be expensive. But it means that we shouldn't have robot juries anytime soon. It means that there could be problems with allowing machine result to be sufficient evidence of guilt without the ability to bring the jury in it. I also have a question here from a brilliant former student, Kian Tamadani. Hi. To the extent the courts end up overseeing validation of interpretive predictive models, do you see us going in the way of specialized courts or even departments within state courts akin to patent boards that are equipped to handle necessary judicial functions? This is something that I think for purposes of bench trials, you have judges who develop certain expertises, like through multi-district litigation, for example, or Agent Orange or whatever. We have a fair cross-section when it comes to juries. We have a fair cross-section requirement, so it would be hard to have like specialty juries. But in terms of specialty courts, like we have for patents, I think that may be a possibility. We don't want to have only, geneticists deciding, major decisions in criminal cases. But I do think that we could have specialized courts looking at some of these more historical fact issues. And, all of this stuff is decided by plea bargain right now. Anyway, it would be great to be able to re-empower the jury in some of these cases to deal with the much harder questions of, whether this person was reckless, let's say, these evaluative facts that the jury is the ultimate expert on because they involve moral condemnation by the community. I know we only have 7 minutes left, and luckily we've been kind of getting some great questions throughout. So I only have just a few more minutes, and then I'll try to make sure that we actually have at least a few minutes at the end. So I'll go quickly through this. But in terms of legal doctrine, yes, we do have rules that have been applied to AI and algorithms in the courts, including authentication requirements that just impose a basic, very low bar, as those of you who remember your evidence or litigate know, very low bar for authentication. And yes, there's something in there that says that if it's a result of a system or a process, you've got to show that it's accurate. But that's just for admissibility, and everything goes to weight, not admissibility. And then Fry and Daubert. But again, that's just, by a preponderance, whether or not something is valid enough to be admitted. It doesn't give you the scrutiny that you get through confrontation. Confrontation of the machine witness itself. Okay, so this is what I stay up at night thinking about. Just to the question about the programmer, you've got these two lines. One of these was written by William Shakespeare. The other was written by an algorithm. What's in the brain that ink may character which hath not figured to thee my true spirit? And King of Hell, no quarrel have I left thee, no lovely maid who gleamed in fields or skies. So to think to yourself which one of these you think is Shakespeare. And the answer is that the first one is Shakespeare, and the second one is an algorithm. Now, maybe you got it right, maybe you got it wrong. My point here is, I don't think a person wrote that. Maybe a person has intellectual property rights over it because they created the algorithm. Maybe the person is morally responsible if this ends up defaming someone. But this person did not write this line. It was written by an algorithm. Okay. This is the Justice Liu dissent that I just love in People versus Lopez, when the gas chromatograph result came in without even a, Kelly Fry hearing of any kind. The Supreme Court hasn't decided whether machine-generated results invariably lie beyond the reach of the confrontation clause, and I express no ultimate view on this issue here. I simply note that as a result of ever more powerful technologies, our justice system has increasingly relied on ex parte computerized determinations of critical facts, determinations once made by human beings. The crime lab's reliance on gas chromatography may be a marked improvement. The allure of technology is its infallibility, its precision, its incorruptibility. But I wonder if that allure should prompt us to remain alert to constitutional concerns, lest we gradually recreate through machines, instead of magistrates, the civil law mode of ex parte production of evidence that constituted the principal evil at which the confrontation clause was directed. Channeling his inner Antonin Scalia there from Scalia's Crawford versus Washington opinion. Before you start saying, what is she talking about? Of course, the Sixth Amendment is not talking about machines. It doesn't say you have a right of cross-examination. It just says you have a right to be confronted with the witnesses against you. And you might think, well, what about the word witnesses? Obviously, witnesses are humans, not machines. But I would direct your attention to the next clause, which is compulsory process for obtaining witnesses in your favor. And since the very early days of the Republic, since the Aaron Burr case, where Chief Justice John Marshall said, no, this isn't just about people. You have the right to subpoena things, documents, physical objects. Witnesses includes documents and physical objects. Okay, great. So to confront witnesses, you would think witnesses, if the thing creating this information against you is a machine, well, we've got to have some sort of confrontation of that as well. And you might think, well, that's not what the framers were thinking, because they were thinking cross-examination. this is sort of what I'm working on right now, that this obsession with cross-examination, look, I was a trial lawyer. I love cross-examination, nothing I love more, but it's a recent development. And some historians have noted that the rise of cross-examination has really been recent enough that it's related to the rise, I hate to say it, of the lawyerly profession, and not necessarily that the founders even thought that there was a right of cross-examination. So to think of confrontation as solely cross-examination is ahistorical. It also makes no sense policy-wise, because it leaves all of these computer programs just, without enough scrutiny. All right, so if you want to talk more about that, send me an email and I'll talk your ear off. But when John Henry Wigmore says that cross-examination is the greatest legal engine ever created for the discovery of truth, that may be true for some human witnesses, not really for eyewitnesses who probably are not lying and simply are mistaken, but definitely not true for machines or dogs. This relates to, I think I'll just run through this without going into detail, but if you would like to talk more about some of the doctrinal developments over the years that I think support the argument that machine confrontation might involve discovery, out of court discovery of a bunch of stuff that's important to scrutinizing the machine, rather than simply real-time in-court confrontation. There's lots of examples of this. Jenks, my favorite case of all time, Craig v. Maryland, just lots of stuff already there that point to the fact that confrontation is a broader concept. My colleague Rebecca Wexler has talked about how the Stored Communications Act has stopped criminal defendants from being able to subpoena critical computer, electronically stored information. And again, so much to talk about. I think if I'm right, we may have time for one or two more questions, but otherwise, feel free to reach out to me to say hi and further questions. I love to talk about this stuff, especially with Berkeley Law Alumni. So I'm going to stop the share and feel free to catch me, but otherwise, thank you so much.
Thank you so much, Professor Roth, for such a thought-provoking talk, and thanks to everyone here for attending. Just a reminder to those in Silicon Valley and San Francisco and Los Angeles, we have some hikes planned this month, and then Dean Chemerinsky is going to provide a Supreme Court review in late June, and then Professor Bratt will give a talk on July 14th. You can register by going to the alumni events page on the school's website. Again, for those who attended today and filled out the MCLE form, which was shared in the chat, you'll receive an MCLE certificate via email within a couple weeks. Thanks very much for being here today. Take care and be well.